Good evening, everyone. It's a pleasure to welcome you again to this webinar series. So I would like to welcome all our distinguished guest participants, colleagues, students, and any members of the public to this webinar. And I would like, on behalf of the Law School of UCAN Cyprus, to wish you all an enjoyable webinar. It's a real pleasure for me to welcome you all this evening and to discuss with you and among us the purpose of tonight's webinar, which is to look at the principles of accountability and transparency and their relevance to the legislative branch of power. I would like to thank very much the British High Commission in Nicosia for their support in the organization of this series of webinars, including through the extending invitation to guest speakers, such as our distinguished speaker tonight, as well as our distinguished speakers themselves, Deputy High Commissioner Mr. Ben Rawlings and Ms. Saira Salimi, Speakers Council, House of Commons, Parliaments of the UK, for their willingness to speak to us and their time with us tonight. I thank Deputy High Commissioner Rawlings for having accepted to step in at the last minute, owing to an unavoidable clash in High Commissioner Lilly's schedule. So we are very happy to have you with us. Our main speaker's bio appears on the program of tonight's event, so I hope you will allow me to refer to the audience to her bio rather than enumerate her extensive achievements. We all look forward to listening to her rather. I would also like to thank my colleague and the discussant tonight, Dr. Klearchos Kyriakides, Deputy Head of the School of Law of UCAN Cyprus, for his willingness to support all the webinars, and in particular tonight. And all participants to tonight's webinar, as well as colleagues at the British High Commission and at UCAN Cyprus who have worked on today's event, such as Patrick, Andrea, Kostas, and others. As evidence of our commitment to open education, it's a pleasure and an honor to be able to engage with a variety of participants to the webinar. Participants include students, of course, but also academics, professionals from the public and the private sector, as well as members of the wider public from Cyprus, the UK, and other places. So I think we are very well equipped to have a very fruitful discussion. Before I continue, please be reminded that this webinar is recorded for the purposes of widening access to educational materials and that you have been asked to consent to this. I would please ask you to keep your cameras and microphones off and to use the chat function in the MS Teams classroom to ask any questions or make any comments. I will be monitoring the chat. If you do not wish to appear at all on the recordings, then don't use the chat function either. Can I please remind you all that each speaker and other participants will take part in this webinar for educational purposes in an educational setting, which means that each participant will provide verbally, electronically, or otherwise any statements, and that must be accepted or must not be accepted or interpreted as either legal advice or any form of advice at all. You may view materials at your disposal in the Microsoft Teams Classroom folder. You are free to take away such materials with you, but just make sure that you placed all necessary acknowledgements. Subject to the professional background of each attendee, participation may contribute to your formal or informal CPD or professional development or other self-managed learning and development needs. Cyprus registered lawyers have been asked to provide their registration number so that we may report their CPD hours for this webinar on the Cyprus Bar Association platform. It is, however, necessary to attend the whole duration of the webinar to collect the hours. Let me say a few words about this webinar series on access to public sector information, transparency in the various branches of power, of which tonight's webinar constitutes the second in the series, with a focus on parliamentary transparency. The main aims of the series are twofold. On the one hand, to promote greater public awareness of what is meant by transparency, open justice, access to public sector information, and related principles. On the other, to reflect upon the British experience of applying these principles in practice in the context of the newly passed law on the right of access to public sector information of 2017 in the Republic of Cyprus. This law that came actually into force in December 2020. I think we can agree that this webinar series participates actively to the wider framework of the rule of law and its upholding in Europe, with particular emphasis on the southeastern Mediterranean. The universal lens of core legal and constitutional principles also lends itself to far-reaching implications for the UK, the Republic of Cyprus, and other democratic sovereign states, which belong to the Commonwealth, the Council of Europe, or both, as will be explored through the webinar series tonight. I believe we can also agree that the timing of this webinar is of essence, considering the forthcoming legislative elections in the Republic of Cyprus on 30th of May 2021, which is this Sunday. With that in mind, tonight's webinar will delve into the principles of parliamentary transparency and accountability of relevance not only to legal professionals, but also to the wider society, by offering a definition of the terms, by explaining how parliamentary transparency and accountability have been applied in the UK by the Parliament, particularly with the aims of publicising parliamentary proceedings and encouraging public participation in those proceedings, by considering the statutory and common law context vis-à-vis freedom of information, data protection, and parliamentary privilege, by assessing how the UK Parliament and the Independent Parliamentary Standards Authority have promoted parliamentary transparency and accountability in relation to the pay, allowance, costs, and interests of parliamentarians, and by highlighting the educational benefits of parliamentary transparency and accountability. These are ambitious aims, which of course I leave in the expert hands of our distinguished guests tonight. I'm sure that opportunities for comments as well as wider discussions and considerations will arise in the second part of this webinar. To start the discussion, however, let me point the audience to a few key indicators of parliamentary transparency and accountability in the Republic of Cyprus. As part of the newly established European rule of law mechanism, the European Commission reported in its 2020 Cyprus Progress Report, with relevance to parliamentary transparency, accountability, and democratic oversight, that some bills of essence to the rule of law are pending before the House of Representatives. These bills include a draft law establishing an independent anti-corruption authority, a bill on reporting of acts of corruption law with provisions on whistleblowers, a bill on the transparency in public decision procedures and related issues law, including provisions on lobbying, as well as a package of legal measures on the reform of justice. Since the publishing of the European Commission's 2020 report, some progress has been made, but remains timid, taking into account the scale of corruption publicly exposed on the island in the past year. In addition to draft legislative measures, the European Commission's reports on the pending code of conduct for MPs, as well as a sanction regime for non-compliance with asset disclosure rules. At the European level, the Council of Europe's Groups of States Against Corruption, GRECO, in its fourth evaluation round, second compliance report on Cyprus, published on the 17th of November 2020, reported on corruption prevention with respect to MPs by assessing a series of 8 recommendations, none of which were found to have been implemented satisfactorily by the time of the review. These recommendations touch upon the transparency and monitoring of MPs' remuneration and benefits, a code of conduct, a code of ethics for MPs and staff, enhanced preventive measures against conflicts of interest with strong disclosure requirements, consistent rules of on acceptance of gifts, hospitality, and other benefits with valuation and reporting procedure, detailed assessments on third-party impact with rules on interaction with third parties, strengthened regime of asset declarations, independent and effective mechanism to monitor declarations of assets, integrity policy with handbook and training for MPs. To these recommendations, I think should be added the visceral need for democratic oversight in a modern state exercised by parliaments. In today's context of the run-up to Sunday's parliamentary elections in the Republic of Cyprus, in times of pandemic, transparency and accountability to the wider society are more fundamental than ever, as they entail prevention and protection. From an initial search I did in the past few days on the democratic framework in place for Sunday's voting, aided by Andre Manoli, whom I thank, I could only identify specific measures to facilitate electronic voting from outside of the Republic of Cyprus, which is of course welcome, as well as a general voting guide, all in the Greek language, where the terms pandemic, social distancing, and the likes did not appear to feature at all. Special circumstances to exercise our basic democratic right of vote in times of pandemic, with all it entails, appear to be missing. Even if they are not, such special circumstances do not seem to be obvious nor visible to the ordinary voter, raising the issue of parliamentary transparency and accountability in the process. But let me give the floor to our guest speakers tonight, who will no doubt provide us with their insights from a UK perspective. Starting with you, Deputy High Commissioner Rawlings, please, for your opening address. Thank you very much.
Well, thank you very much for setting the scene. And as you said, the High Commissioner is sorry he can't be with us tonight, but I'm quite happy because it means I get the chance to be with you instead. And on behalf of the British High Commission in Cyprus, we're delighted to be supporting this series of webinars and congratulate you on delivering them, a way of adapting to the limitations of the pandemic, but to carry on with this important work. And in this case, in this series of webinars around promoting greater awareness of what is meant by transparency and why it is so important in making states more open and accountable. And I should note as well, it also marks the increasingly strong relationship between the High Commission and UCLAN, building on previous collaboration that we've had, and the first webinar looking at transparency in the judiciary. And this is all important to us because of part of the UK's Global Britain strategy, and a big part of that strategy is around being a force for good in the world. One of the key pillars of that, how we deliver that, is our support for open societies. It's something we're committed to working in partnership with the Republic of Cyprus on, promoting openness and transparency. But why is that important to us? Well, greater transparency is a hugely important objective for us, quite simply because of the wide and positive impact that it has. Transparency can really transform people's lives for the better. It's a key aspect of enabling fairness. It enables countries to collect taxes and perform the functions of the state, to improve public services, and to ensure a level playing field in which business can flourish and in which individuals can enjoy their life and liberty. At the core of the UK's anti-corruption strategy is our work to enhance international transparency, supporting citizens and organisations to use information and data to create stronger accountability. But transparency isn't only about information availability, it's also about the ease of access, the understanding and usage by citizens and by organisations. So transparency is an important tool to help prevent and detect corruption, but it also builds confidence that our public and private institutions are fair, impartial and effective. And that's, we can't underestimate the importance of that in society as well. You already mentioned a little about how Parliament and the Legislature is a key part of all of this, and why transparency in Parliament and in the Legislature is important. In December last year, Sir Lindsay Hoyle, the Speaker of the UK House of Commons, addressed the Cypriot Parliament, again virtually, which was another step in the strengthening of the relationship between the UK and the Republic of Cyprus legislative branches. In his address, Sir Lindsay highlighted the breadth of our shared values as both members of the Commonwealth family, but as democracies and countries that share our belief in the rule of law. So, continuing that theme and that relationship, I'm really pleased today that we have Ms. Saira Salimi here, the Speaker's Counsel in the House of Commons, who will be able to not only develop a bit about why this is important in Parliament, but also to offer really invaluable insights, I think, into how parliamentary transparency and accountability are being implemented in the UK Parliament, and some of the challenges that we face and how we overcome some of those things. So I'm really pleased and grateful to you, Clan, for bringing us all together again in this forum to discuss and share experiences, expertise from the UK and from the Republic of Cyprus, and perhaps even from elsewhere, so that we can create an exchange of views, some new ideas about how, as two countries, we can work ever closer together to promote transparency at home, in Europe, across the Commonwealth, but also even in the wider world. So thank you all very much for hosting this. Thank you everyone for participating. I'm delighted to hand over to experts with far more interesting things to say. Thank you.
Thank you very much, Deputy High Commissioner, for inviting us to reflect together. This is very welcome. Now, let me turn to our keynote speaker for tonight, Ms. Saira Salimi. We are very happy to have you, very privileged, and the floor is yours for half an hour. Thank you very much.
Thank you very much, and thank you for inviting me to participate in this webinar. I'm very honoured and very pleased to be able to join you. I should stress at the beginning of this that I'm speaking very much as a practitioner and as a legal advisor to the House of Commons, dealing with the practical day-to-day problems that arise in the court.
Saira, you muted yourself by mistake.
Thank you very much for telling me, and apologies, I must have caught the space bar. I'm sure there are many interesting points to be drawn out of my practical experience, which others on this webinar are much better qualified than I to draw out. But I just want to give you an outline, which I hope will be the basis for an interesting discussion. My focus today is going to be mainly on the present statutory framework for openness and transparency, particularly data protection and freedom of information, as it applies at Westminster. But before I begin, I do want to briefly outline the context into which that legislation was introduced, the non-statutory arrangements for transparency as they applied to proceedings in Parliament before that statutory framework came in. I'm going to start, as all good parliamentary lawyers do, with the Bill of Rights of 1689, which would, from its inception, have provided protection for reports of parliamentary proceedings had Parliament wanted reports of its proceedings to be published. However, I'm sorry to say that at that period it did not. 5 years after the Bill of Rights was passed in 1694, the House of Commons passed a resolution against intermeddling with the proceedings of the House. Over the following century, many writers and editors were brought to the bar of the House to be admonished for publishing reports of its proceedings. In 1738, the House passed a resolution that it is the high indignity to and a notorious breach of the privilege of this House for any news writer in letters or other papers to give therein any account of the doings or other proceedings of this House or any committee thereof, as well during the recess as the sitting of Parliament, and this House will proceed with the utmost severity against such offenders. Notwithstanding that resolution and the occasional arrests and imprisonment of those who reported on proceedings in Parliament, parliamentary reporting grew rapidly because people wanted to know, particularly with the development of the printed press in the course of the 18th century. The Parliamentary Reports in a form that we would recognise today really begin in 1803 with the printing of Cobbett's Parliamentary Debates, when each house reluctantly and unofficially began to admit reporters to their proceedings. The reports began to be printed by Thomas Curzon Hansard, which is a name everyone on this webinar will recognise, in 1808. Even by the early 19th century, publishing accounts of proceedings in Parliament was not risk-free. Cobbett and Hansard both spent time in prison for publishing criticisms in their reports. Cobbett was bankrupted and Hansard bought out his interest in the reports, which subsequently became known from 1812 as Hansard's Parliamentary Debates. In 1909, Parliament, having finally fully embraced accurate reporting of its proceedings, Hansard was taken in-house and became known, as it still is, as the official report. Further moves towards greater openness and transparency in formal proceedings followed. Proceedings have been broadcast on the radio since 1975. They've been broadcast on television since 1989. Nowadays, thanks to the wonders of the internet, the House broadcasts its own proceedings online through Parliament Live TV. All proceedings in the chambers are routinely broadcast, as are a number of committee meetings. Hansard transcripts of proceedings in the chambers are available online within 3 hours of debate. Evidence to select committees and public bill committees is routinely published online, with only rare and very limited exceptions. Moving into the 21st century, the House has also embraced electronic petitioning by citizens, and any petition which obtains 100,000 signatures gets a debate in Westminster Hall on the subject of the petition. The Petitions Committee, which is the gatekeeper for public petitions, is very active and has been kept very busy. So for at least the past 100 years, Parliament has taken the view that it is in the public interest to be very open and very transparent about what goes on in its formal proceedings, to the extent that those are open to the public. And of course, in ordinary non-COVID times, it is perfectly possible as an ordinary member of the public to arrive in Westminster and to sit in the public gallery during sitting in the chamber, or to sit at the back of the room in the course of a committee debate. So in addition to that aspect, that very important aspect of transparency, which is knowing what is said in Parliament, I ought to mention also the conventional expectations of those who are participating in Parliament. And government ministers in particular are expected to be frank and to make significant announcements to Parliament first. In the 1990s, both houses made resolutions in the following terms, following a recommendation of the House of Commons Public Service Committee. The resolution says that in the opinion of this House, the following principles should govern the conduct of ministers of the Crown in relation to Parliament. Ministers have a duty to Parliament to account and be held to account for the policies, decisions and actions of their departments. It is of paramount importance that ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity. Ministers who knowingly mislead Parliament will be expected to offer their resignation to the Prime Minister. Ministers should be as open as possible with Parliament, refusing to provide information only when disclosure would not be in the public interest, which should be decided in accordance with relevant statute and the government's code of practice on access to government information. This predates the Freedom of Information Act, I should say. Similarly, ministers should require civil servants who give evidence before parliamentary committees on their behalf and under their directions to be as helpful as possible in providing accurate, truthful and full information in accordance with the duties and responsibilities of civil servants as set out in the Civil Service Code. Those resolutions were presented as clarifying the role of ministers in relation to Parliament. They were not intended to affect or derogate from the duties that ministers already owe to Parliament in their capacity as members of either of the houses, and in particular the expectation that all members will be honest and truthful with Parliament. During the recent debates on the exit of the EU from the UK from the EU, that expectation of frankness with Parliament was relied on by the opposition and others to obtain documents through a parliamentary mechanism known as the humble address, which had been used through the 20th century primarily for purely formal proceedings, such as the response to the Queen's speech, but was repurposed as a means of requiring ministers to provide particular information to the Houses. So much then for the formal proceedings of Parliament, in respect of which the fundamental expectation is, and has been for a very long time, that Parliament is open and transparent. Even for formal proceedings, there are some exceptions, of course. Proceedings that are not published, such as the minutes of a private meeting of a committee or correspondence between a committee and a potential witness, are not routinely published and are protected by parliamentary privilege. It's a contempt to make them available without the leave of the House. The only way to obtain unpublished parliamentary papers is by petition to the relevant House. And the outcome of such a petition is by no means guaranteed to be positive, as Kevin Maxwell discovered in 1995 when his MP petitioned the House for unpublished parliamentary material to assist him in his prosecution for fraud. The House of Commons refused that petition, and I'm going to put a link to the Hansard record of that petition in the sidebar, which I hope will work. That has appeared. But what about other matters about the House's own administration? The transparency that applied to formal proceedings was not applied to the inner workings and administration of the House service. It might be helpful at this point to explain that the internal governance of the House of Commons is actually quite complex. The House is not a legal entity, and so two statutory bodies have been created to enable it to operate effectively in the modern world. The House of Commons Commission is responsible for the employment of House staff and is also required to set the strategic direction of the House service. And that was created by the Parliamentary Administration Act of 1978. The Corporate Officer of the House is a corporation sole created by the Parliamentary Corporate Bodies Act 1992, and the Corporate Officer has the power to own and deal with land and to sign contracts on behalf of the House. The Corporate Officer is the Clerk of the House from time to time, and the House of Lords also has a Corporate Officer who is the Clerk of the Parliaments for the time being. So that quite complex governance structure is the context into which the modern law of freedom of information and data protection was introduced. And I'm mentioning the two together because although the purpose of the legislation is very different, each enables individuals to make requests of a public authority and entitles them to have those requests considered and in most cases answered. So I'm going to take data protection briefly first. Which begins in the UK with the Data Protection Act 1998. That act didn't initially apply to Parliament. It was amended later to provide that the two corporate officers were the data controllers for the two houses. And there was an exemption for Parliament in any circumstance where compliance with the Act and provision of information, or indeed steps to protect somebody's personal data or to erase somebody's personal data, would infringe the privileges of either house. The General Data Protection Regulation in 2018 significantly expanded the responsibilities of data controllers generally, and the corporate officers particularly, and it also reduced the scope of the exemption that was available for parliamentary privilege. The Data Protection Act 2018 includes specific derogations to allow for parliamentary privilege, but only, of course, to the extent that the original EU regulation permits derogation. The government also legislated to provide expressly, for the avoidance of doubt, that the reference in Article 6 of the GDPR to a task carried out in the public interest or in the exercise of the controller's official authority included the exercise of the functions of either House of Parliament. So, for example, data subjects have no right to rectification or to erasure of their data if it's contained in proceedings of either House, because it would be an infringement of the privileges of either House to remove that information from the record of proceedings. Practical circumstances in which that might arise are, for example, if a witness gave evidence referring to somebody's personal data and the data subject considered that that information was inaccurate, or if a committee report included personal data that the data subject would prefer not to be in the public domain. Requiring erasure or rectification in those circumstances would be an infringement of the privileges of either House, and therefore is not required under the Data Protection Act or the GDPR, where it would otherwise be required of a data controller. I should say that the UK's departure from the EU has made no difference to the application of the GDPR, which continues to have effect as retained EU law under the EU Withdrawal Act of 2018. The Data Protection Act 2018 is, of course, UK primary legislation and would in any event have been unaffected by the UK's departure from the EU. As all public authorities do, the two houses receive large numbers of subject access requests for the whole range of reasons that other public bodies do. The Information Rights and Information Security team of Parliament is responsible for handling those requests and is headed by the Data Protection Officer for the House of Commons. Parliament is subject to the same time limits and other obligations under the data protection legislation as other public bodies, and it can sometimes be a challenge to respond to requests in the statutory timeframe. And that's especially the case when someone is seeking information for the purposes of a dispute and a substantial amount of information is held. And in particular, I think probably in common with many other bodies, we find that subject access requests are often used as a means of obtaining information in advance of beginning legal proceedings. So they're a useful tool in the hands of the data subject for obtaining information which is held about them by a public body. Where information isn't subject to parliamentary privilege, the two houses, of course, have other lawful bases for processing data, such as the employment of its own staff or cooperation with the police for the prevention or detection of crime. I hope that the stricter legal framework that was introduced with the GDPR has made us much more conscious of the data we hold and of our lawful basis for processing it, but it hasn't fundamentally changed the nature of the data we hold or of what we do with it. It's merely encouraged us to consider how long we hold it for and to ensure that we're providing proper information to anybody engaging with us in any capacity, so that people are clear in advance about what we'll do with their data and how long we'll hold it for. So that's significant as a very wide range of people engage with Parliament every day. Obviously, there are members and their staff, there are House staff, there are witnesses to committees, there are visitors in non-COVID times, there are contractors, there are journalists, there are civil servants, there are police and law enforcement officers, and there are many others. Before I move on to freedom of information, I just want to add a word about data protection and members of Parliament. Each member of Parliament is responsible for the proper use of the data that they hold in that capacity, which is the data that they hold as employers of their staff, and of course data collected in the course of the constituency work that they do. They are the controllers of that data for the purposes of data protection legislation. The House Service provides a computer network with appropriate security for that data, but it acts as a processor, not a controller, under data protection legislation in connection with it. The House can't deal with that information except on instructions from the member. If the member resigns their seat or loses it at a general election, there's a grace period for them to wind up their office, and then the information that was held on their behalf is deleted from the network in accordance with our contract under the GDPR with members of Parliament. So that brings me finally to our freedom of information legislation, and I'm very interested to hear that the Republic of Cyprus is, as we speak, in roughly the position that the UK found itself in 2005, when freedom of information legislation was first in effect. The Freedom of Information Act 2000 was quite new as a legislative provision for the UK, in contrast to the long-standing expectation that there was transparency about proceedings in Parliament. And the activities of government in particular were generally kept much more confidential than is the case now. There were some voluntary codes of practice, and I referred to one of those earlier when I mentioned the resolution of the House about ministerial frankness with Parliament. But they were voluntary, and it was up to government to police them. The Freedom of Information Act was a new experience for the UK, and there was a 5-year grace period in between its passing in 2000 and its coming into force after royal assent, reflecting the scale of the cultural shift that it represented. So it came into force in 2005 and it applied to each House of Parliament. By way of very brief outline, the UK Freedom of Information Act provides as the basic proposition in section 1 of the Act that a person who makes a request under the Act is entitled to be told whether the public authority holds the information and to have the information communicated to them if the public authority holds it. Of course, that right is not absolute. There are a number of exemptions contained in Part 2 of the Act, and they are of the kind that you would expect. Personal data is, of course, one. There are exemptions for national security, for international negotiations, and for a number of other matters, including prevention and detection of crime, which is one which is periodically of relevance to Parliament. Some of those are absolute exemptions, and some of them require a balancing test to be applied by the public authority between the public interest in the release of the information and the protection of the relevant interest. So, to take an example which is of significance to me and to my team, legal professional privilege is a ground for exemption, but it isn't an absolute ground for exemption. If the public interest outweighs the interest in the confidentiality of communication between lawyer and client, then the Act requires that legal advice may be disclosed. So, thinking about the exceptions under the Act that apply specifically to Parliament, there is an exemption under section 34 for a disclosure that would infringe parliamentary privilege. There is no obligation to release information or confirm or deny its existence if doing so would infringe the privileges of either House of Parliament. That's an absolute exemption. There's no requirement to balance the public interest in the request being answered against that infringement. And the Speaker's certificate that section 34 applies is conclusive evidence for the purposes of the Act, and no further inquiry or challenge is possible. From the parliamentary legal perspective, then, that leaves intact the position that I described earlier, that where information is privileged and hasn't already been published by Parliament, the only way to obtain it is to petition the House for it, and that the response to such a petition is not guaranteed to be yes. I will incidentally put a link to the UK Freedom of Information Act in the sidebar. I hope this is accessible to those outside the UK. I think it is. I hope that's visible if anybody wants to look up the relevant provisions. And the other provision in respect of which special provision is made for Parliament is section 36 of the Act, which exempts information if its release would lead to the prejudice of the effective conduct of public affairs. And that provision applies not to all public bodies, but to central government, ministers of the Crown, to the Westminster Parliament, and to the devolved legislatures in Wales, Scotland, and Northern Ireland. It allows information to be withheld by a public authority if, to paraphrase the Act slightly, it prejudices Cabinet collective responsibility or Executive Committee authority. It inhibits the free and frank provision of advice or the free and frank exchange of views for the purposes of deliberation, or it would otherwise prejudice the effective conduct of public affairs. And in the case of the two Houses of Parliament, the application of those provisions is backed up by a certificate that, in the reasonable opinion of the Speaker of the House of Commons or the Clerk of the Parliaments, as the case may be, one of those tests is met. For the two Houses, though not for the other bodies to which section 36 applies, that certificate is conclusive evidence that the information is exempt. Challenge might be possible via judicial review on the grounds that the opinion of the Speaker or the Clerk was not reasonable, but that would be the only avenue of challenge to a decision under section 36. For other bodies, a certificate may be issued but is not conclusive evidence, and therefore those other bodies may have to prove that the exemption applies. As a very sweeping proposition, I would say that the primary difference made by the Freedom of Information Act, given what I've already said in the course of this talk about the very wide and very wide-ranging transparency that already applied to Parliament's formal proceedings, is that the Freedom of Information Act has imposed greater transparency in the matter of money. Financial information that wasn't routinely published before the coming into force of the Act now is, because if it isn't proactively published, it will be requested under the Act. Many of the people listening to this webinar will remember the members' expenses claims of 2008 and 2009, which was a readjustment to the reality of greater financial transparency. Freedom of information requests for members' individual expenses claims were initially refused, but before the process could play out through a complaint under the Act and eventually proceedings in the courts, a British newspaper published leaked information about those expenses. The resulting scrutiny, which led to criminal prosecution for a few members where the claims had been actually fraudulent, led to the creation of a new statutory regime for members' expenses and salaries, and an independent statutory body, the Independent Parliamentary Standards Authority, known generally as IPSA, which was created to regulate members' expenses claims and to make decisions about their salaries. Expenses claims are now routinely published each year by IPSA, with the one exception that they don't routinely publish independent. I do beg your pardon. They don't routinely publish individual members' spending on security because there is an obvious reason why that should not be published at the individual level. They only publish a global figure for spending on members' security generally. So Parliament has a long history of transparency in relation to its formal proceedings, and following the introduction of the Freedom of Information Act 2000, it also has an ever-increasing transparency about its financial dealings and its internal workings. It regularly responds to Freedom of Information Act requests on a whole range of issues, and the majority of those requests are accepted and the information is published. Very often when a request is refused, in fact, it is refused not on the grounds that the requester may not have the information, but on the grounds that the information has already been published by the House proactively. And therefore, the requester will simply be pointed to the place where that information is published online. So I think I am very near running out of time, and I think that your questions may very well be more interesting than anything that I've had to say. So I will stop at this point and hand back to our distinguished chair.
Thank you very much, Saira. That was extremely informative, and I think it actually goes beyond what I had even imagined in terms of greater transparency, as you said. So this is very, very interesting, lots of food for thought, and it's very interesting that it is placed in such a modern setting, the setting of Data Protection and Freedom of Information Act. So that's very, very helpful. Thank you so much. Laulhé, now the floor is yours. You have half an hour, but you can take more time. I mean, we are well on time. Thank you very much.
Thank you for that kind introduction. I begin by thanking the British High Commission for kindly supporting this event, my own university for hosting it, our distinguished guest speaker for her contribution, and everybody else who's worked behind the scenes to prepare for today's webinar. I'm going to give you a presentation that I've entitled Parliamentary Transparency and Accountability, 6 Lessons Arising from British Politico-Legal History. Before I plunge into the detail, I can't let a webinar on Parliament go without referring to Winston Churchill. So I'm going to begin with a Winston Churchill quotation. I put in this system, hopefully the attendees have received it. I'll send it again just in case. It's this passage from Hansard, the official record of Parliament from the 11th of November 1947. This is what Winston Churchill said. Many forms of government have been tried and will be tried in this world of sin and woe. No one pretends that democracy is perfect or all wise. Indeed, Churchill added, it has been said that democracy is the worst form of government, except for all those other forms of government that have been tried from time to time. Now, back in 1947, Winston Churchill was the former Prime Minister, having left office in 1945, and therefore he was leader of the opposition. But what he said in those remarks, which were delivered during the debate over the then Parliament bill, those remarks reflect my own views as to the wonders and the pitfalls of democracy, which has many strengths, but also many weaknesses. But perhaps two principles at the heart of democracy that ensure that Parliament is meaningful are these two principles that I'm going to discuss today: transparency and accountability. In other words, my argument, if I do have an argument today, boils down to this: without transparency and accountability, democracy counts for nothing. It's meaningless. It's just a shadow of what it is. So to put it more positively, if a society has transparency and accountability built into its legislative branch of government, it's much more likely to have a tangible form of democracy that is able to fulfill the primary function of democracy, which is to serve the people and to protect its security, its interests, and overall welfare. So with that preliminary comment in mind, let me now turn to my 6 lessons of history. There are 6, and I'm going to begin with the first one. Parliamentary transparency, accountability, and democracy each hinge upon a contemporaneous, authoritative, and accurate official record of parliamentary proceedings, coupled with other accurate parliamentary materials. Hansard is the guarantee of that in the modern British parliamentary context, and as I'm going to explain with reference to my second lesson, Hansard's not enough, but Hansard is our starting point for ensuring the existence, at least in the United Kingdom parliamentary context, of a contemporaneous, authoritative, and accurate official record. Now, why is that important? Well, the details are set out in a paper that I've composed, that I've placed on the file part of the Microsoft Teams box of this webinar. And in the aftermath of today's webinar, I hope that paper can be circulated more widely. But in essence, the meaning and the history of Hansard is set out in a wonderful book freely available online on the website of Parliament. It's called The History of Hansard. It's written by John Weiss and Stephen Farrell. It includes a foreword by the then, it was published in 2017, the then Speaker of the House of Lords, Lord Speaker, to give him his full title, Lord Fowler, former Conservative Cabinet Minister. And among other things, Lord Fowler noted that this history of Hansard reminds us that Hansard has been producing an official report of proceedings in the House of Lords and the House of Commons since 1909, but an unofficial version dates back to 1803. And the history of parliamentary reporting stretches back to the English Civil War. Indeed, Lord Fowler adds, the history of reporting political events goes back much further, through ancient Greece to the Egypt of the pharaohs. So what Hansard does by recording in writing what has been said verbally in either the House of Commons or the House of Lords is part of an ancient tradition. But what Hansard has done, I would suggest, is it's modernized the concept, and also Hansard is kept up to date with developments. As we've just heard from our distinguished keynote speaker, Hansard doesn't just produce traditional written versions of the spoken word. It also these days uploads on the parliamentary website the electronic transcripts of what has been said verbally, and Hansard is also now supplemented with the electronic archive of video recordings of parliamentary proceedings. And in their book on the history of Hansard, John Weiss and Stephen Farrell explain why this is so important. And it boils down to this, and I quote, "Spoken words are ephemeral. They're here today, they're gone tomorrow. Spoken words are ephemeral, but when they are written down, they can live forever. And that's why I was able to read to you those observations of Winston Churchill from 1947, because he uttered those remarks on the floor of the House of Commons. The words floated into the air. They were captured by the transcribers of Hansard, and they were put down in writing, initially published on paper, and these days, thanks to the parliamentary website, they're recorded online for everybody around the world, including academics like me and students, to access and make use of, and to criticize and to support and to do everything else that is associated with democratic debate and academic research. In their book, Weiss and Farrell add something else, which I think is very important for those of us who are trying our best to promote democratic values and a democratic culture. Hansard, they explain, is a working document. That means that MPs and peers use Hansard from day to day while arguing over political issues and holding the government to account. And it's also a vital historical and legal record of what was said in the past. Its primary significance is still to be, just as it was in the 18th century, in giving people a full, accurate, and authoritative report of everything that is said and done in Parliament. Those members of Parliament are in Parliament to serve the people collectively and their individual constituents if they're sitting in the House of Commons. In the House of Lords, they don't have constituents and constituencies to worry about. But they are there, whether they're in the House of Commons or the House of Lords, or in any other legislature around the world, to serve the people in which their Parliament happens to interrelate with. And therefore, the words that they use in Parliament, in a sense, are theirs, but they belong to the people. And how is the people going to discover what was said unless there is a proper mechanism of transmission? And that's why Hansard and the equivalents of Hansard around the world are so important, because they enable the ordinary citizen to plug into Parliament and to find out what was said, when it was said, why it was said, and what the consequences of what was said were. Now, for the lawyers in the audience, it's important to bear in mind that in the United Kingdom parliamentary context, and indeed in our legal tradition in the United Kingdom, or to be, I tend to say in England and Wales, but I will refer to the United Kingdom in this context. In our legal tradition in the United Kingdom, until relatively recently, there was in fact a rule whereby parliamentary proceedings would not be cited in any court of law, and that's partly because of the Bill of Rights of 1688, which I'll come to later, which effectively does create a form of privilege that attaches itself to parliamentary proceedings. But there was a problem with that old approach, because it meant that in certain cases, when the courts were striving to ascertain the meaning of a particular piece of legislation, that the answer was in a ministerial explanation given to Parliament at a time when the then bill was passing through, but the courts were blocked from gaining access to Hansard because of the traditional approach. Well, there was a landmark case decided. It's called Pepper in brackets Inspector of Taxes and Hart, reported in 1993, which broke new ground, or rather went back to a bygone age where the previous rule didn't exist. The essence of the Pepper and Hart rule was beautifully encapsulated by the late Lord Kerr in his judgment, with whom his four fellow justices agreed in the case of the Crown and Adams. This is a case from Northern Ireland that ended up in the Supreme Court of the United Kingdom. And Lord Kerr, with reference to Lord Brown Wilkinson in Pepper and Hart, said the following: the rule in Pepper and Hart can be succinctly stated. As Lord Brown Wilkinson said in Pepper and Hart, reference to parliamentary materials in a court of law is permitted, quote, where A, legislation is ambiguous or obscure or leads to an absurdity, B, the material relied upon consists of one or more statements by a minister or other promoter of the bill, together with, if necessary, such other parliamentary material as is necessary to understand such statements and their effect. C, the statements relied upon are clear. So in certain circumstances, it is now permissible for a court of law to dig into Hansard to find out what a minister said when presenting a bill or defending a bill on the floor of the House of Commons or the House of Lords, in order to ascertain its meaning or to ascertain the mischief, in other words, the purpose underlying the bill. What was the aim of the bill? What was the mischief that the bill was trying to address before the bill became an act of Parliament and thus part of the statutory law of the land? Now, the new rule in Pepper and Hart does not extinguish the method of parliamentary privilege created by Article 9 of the Bill of Rights of 1688. That continues to apply. And to remind the audience, the Bill of Rights stipulates in Article 9, quote, that the freedom of speech in debates or proceedings in Parliament are not to be impeached or questioned in any court or place out of Parliament. So out of the Bill of Rights, we have the concept of absolute parliamentary privilege, which attaches to what members of Parliament say on the floor of the House of Commons, or to what peers say on the floor of the House of Lords, and it also attaches itself to certain other related proceedings of the two houses of Parliament. And that is designed to prevent a member of Parliament from fearing the risk of being sued in the civil courts, for example, on the grounds of a breach of the tort of the defamation. So MPs can go on the floor of the House of Commons, make allegations. They've got to be careful about making those allegations, because the Speaker can butt in and try and prevent them from saying things that they perhaps ought not to do. But the general principle is that MPs can stand on the floor of the House of Commons, or if they appear in the House of Lords, and express a view that is arguably defamatory, but they are free of the risk of facing a claim in the county court or the High Court for any civil claims based on, for example, the tort of defamation. Equally, if a member of Parliament makes a defamatory statement on the floor of the House of Commons and it's recorded in Hansard, the media or an ordinary citizen can, provided they're careful in how they recycle the allegation, they can recycle the allegation and be covered in qualified parliamentary privilege. So they've got to be careful. If you're outside the House of Commons and you echo a defamatory statement, you have to be careful to echo it in a very, very careful way that's faithful to what was said in the House of Commons, and you can't go further and abuse privilege. But if you do go down that path, you might be protected up to a point. I'm saying all of this because we had a fascinating case as a result of the MP's expenses and allowances scandal that broke in 2009, if I remember correctly, when the Daily Telegraph published a series of exposés on what certain members of Parliament were doing with the then expenses and allowances system that was operating in the House of Commons. Now, in my handout, I've given you a link to the Supreme Court case that emerged from this. It was called Crown and Chater and Others, 2010. I've also given you a link to a wonderful Daily Telegraph documentary that was published, posted rather, on the YouTube channel of the Daily Telegraph, where you can actually see the MP's expenses and allowances scandal analysed in video form. But the point is that a lot of MPs were unmasked on the basis that they'd acted unethically, arguably, but also a small number of MPs were unmasked for allegedly acting unlawfully. In other words, they strayed allegedly beyond the line that separates lawful and unlawful conduct. And the case is called Chater, and that's after David Chater. David Chater and a number of other MPs were brought before the criminal courts, having been charged with the offence of, let me get my wording right here, they were brought before the court, or Mr. Chater rather, was brought before the court on the grounds that he had engaged in false accounting contrary to the Theft Act 1968. Now Chater put in a defence. The defence was that it was no business of the courts to challenge his submissions in writing to the parliamentary authorities in relation to his expenses and allowances claims, because he argued, or rather his counsel in court argued, those written submissions to the parliamentary authorities were covered by absolute parliamentary privilege under Article 9 of the Bill of Rights. Now, on the face of it, I'll read it to you again. Article 9 says that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. I mean, there was a grain of credibility to that submission, and as a result, the case ended up in the Supreme Court of the United Kingdom in one of its first cases in 2010, and it was founded, of course, in 2009. And the Supreme Court was having none of it. The Supreme Court rejected the arguments or the submissions put forward by Mr. Chater. And I'll read to you what Lord Phillips, the then President of the Supreme Court, said. This captured the essence of the reasoning of the court in rejecting the argument that parliamentary privilege extended as far as the expenses and allowances paperwork that had been submitted by members of Parliament to the then parliamentary authorities. This was before the establishment of the Independent Parliamentary Standards Authority. I'm quoting here from Lord Phillips, President of the Supreme Court, in the case of Chater. Parliament has never challenged, in general, the application of criminal law within the precincts of Parliament, and has accepted that the mere fact that a crime has been committed within these precincts is no bar to the jurisdiction of the criminal courts. In May 1812, John Bellingham was indicted, tried and convicted for the murder of the Prime Minister, Spencer Perceval, at the entrance to the lobby of the House of Commons. Bellingham was not a member of Parliament, but it would have made no difference had he been. In other words, being a member of Parliament or being within the precincts of the Houses of Parliament does not give you immunity from prosecution if you commit a serious criminal offence, such as murder or theft. Lord Phillips added, where a crime is committed within the House of Commons, this may well also constitute a contempt of Parliament. The courts and Parliament have different overlapping jurisdictions. The House can take disciplinary proceedings for contempt, and a court can try the offender for the crime. So against this background, this Supreme Court judgment that held that the Bill of Rights did not extend as far as the written submissions made to the parliamentary authorities, the MPs found themselves in the criminal courts, and David Chater, he pleaded guilty to 3 charges of false accounting contrary to Section 17 of the Theft Act 1968. And in the words of the sentencing remarks of Mr. Justice Saunders, as delivered in the Southwark Crown Court of the 7th of January 2011, the reason for the false accounting was to obtain payment of expenses to which he, that is to say Mr. Chater, was not entitled on the basis that he claimed them. Put another way, Mr. Chater submitted inaccurate documentation to the relevant authorities of Parliament, and in response the judge sentenced him to 18 months of imprisonment. Why is this important? Well, it reminds us that in a democratic society the rule of law prevails, and that nobody, not even an elected member of Parliament, is above the law. What it also does, though, is remind us as to that first lesson that I cited a few minutes ago, and I'll repeat it. Parliamentary transparency, accountability and democracy each hinge upon a contemporaneous, authoritative and accurate official record of parliamentary proceedings, coupled with other accurate parliamentary materials. So fraudulent expenses and accounts, allowances submissions made by an MP to the relevant authorities in order to extract more money than they're entitled to, as occurred in the case of Chater, is not acceptable, and it's a breach of the rule of law. So the second lesson follows on from the first one, and it's this: accurate parliamentary materials are not enough to guarantee parliamentary transparency, accountability, and democracy. Other mechanisms are also necessary. And what I've done in my paper is the UK Parliament's not perfect, and I've just shown you an example of where a few, and fortunately there were a few members of Parliament were caught with their, were found out for putting in untruthful expenses and allowances claims. Now, they're the exception, I hope, but I don't want to make out that the UK Parliament is perfect, but on the face of it, we do have in place in Westminster certain structures of transparency that I would like to see in every parliament across the Commonwealth and the Council of Europe, which are the two organisations that both the Republic of Cyprus and the United Kingdom belong to. So here are just some of them. I'll list them briefly. Firstly, in no particular order, open access to parliamentary premises during working hours, of course. I mean, when I was in the United Kingdom, I used to regularly, I lived relatively close to Parliament. I would just go there out of interest and walk in, especially towards the evening when there were fewer tourists queuing up to go in. Just go in and observe parliamentary proceedings. I used to take students there as well when I was at my previous university. The idea that a citizen can go in and observe parliamentary proceedings is normal, but in some parts of the world it's abnormal. As I discovered when I took some students from other parts of the world, I won't say which ones, and they were almost horrified that it was so easy to get in. Obviously there are security checks, and now in the pandemic there are no doubt additional checks. And but the point is, it's relatively easy to gain access to Parliament, either physically or through the internet. That's very, very important to point out. And we take it for granted in the United Kingdom, but it's something that needs to be part of the culture of every democratic society, subject to appropriate security checks, for example. Secondly, Parliament must be open to the people in other ways. So, for example, when a House of Commons inquiry is instigated, the normal course of action is for there to be a call for evidence from members of the public. I mean, I was lucky enough to spot a number of the calls for evidence by the then exiting the European Union Committee of the House of Commons, which was calling for written evidence during the Brexit process. And I put in a number of submissions which were published, quite rightly, because the last thing we want is to back behind the scenes dealings between members of the public and the parliamentary committee. So I've seen this in action, and a number of other academics have done what I've done, but ordinary citizens should take part in open calls for evidence issued by parliamentary committees, not just in the United Kingdom, but around the world. It should be part of the democratic culture of a democratic legislature for there to be open calls for evidence and relatively straightforward means of submission. For example, when I submitted my various pieces of written evidence to Parliament, to two committees of Parliament during the Brexit saga, all it required was following the online procedure, which is relatively straightforward, and following it up with a parallel communication with the clerk of the committee in question. And the clerks, I have to say, were very, very courteous and helpful. The point is, it shouldn't just be academics who take part in these calls for evidence. Every single citizen who has something meaningful to say should take part in open calls for evidence. But that requires parliamentary committees to issue open calls for evidence and not just conduct the proceedings among themselves for the benefit of themselves. Those parliamentary committees are there for the benefit of the public, not just for the benefit of the individual members of Parliament. We also have in the United Kingdom the culture of surgeries, whereby ordinary constituents can meet their members of Parliament to lobby them, to question them, to put their concerns to them, and so on. We have a number of registers in the House of Commons and the House of Lords. We have, for example, the Register of Members' Financial Interests of Members of Parliament, the Register of Lords' Interests for peers in the House of Lords. We have the requests for information to the House of Commons and House of Lords under the Freedom of Information Act and Environmental Information regulations. We have a series of other transparency publications. And no less importantly, we have the educational and public information documentation published by the UK Parliament website. And can I emphasise this, the House of Commons Library and the House of Lords Library. Hundreds and hundreds and hundreds of books, reports and other documents have been published by the House of Commons Library and the House of Lords Library. During the pandemic, when my students were deprived of physically going into either their university library or a public library, they had access only to electronic resources. Thankfully, our library gave them access to Westlaw and LexisNexis and various online academic journals. But what I was able to do and what colleagues were able to do was to make use of the House of Commons Library materials, because what the House of Commons Library generally does is it provides very helpful potted summaries and analyses of quite complex issues for the benefit of ordinary members of Parliament and by extension ordinary members of the public. And law students, I would encourage all law students to make use of the House of Commons Library. Now that's in a sense it is a form of transparency, because what we're seeing is the documentation that the independent and impartial House of Lords authorities are providing to members of Parliament. So in a way it's a form of transparency, but what it also shows is that transparency has a very positive educational benefit. By putting information in the public domain, the lecturer or the teacher in a school is able to access information and documentation and statistics and other details in order to teach, and the student is able to take advantage of the material in order to learn. And this paper that I've written is 90 to 100%, well, 90% based on published British parliamentary papers. So that's the second lesson. Just read it out again. The second lesson is accurate parliamentary materials are not enough to guarantee parliamentary transparency, accountability and democracy. Other mechanisms are also necessary, and they include what I've highlighted: open physical access to Parliament, and these days electronic access to Parliament, coupled with other such mechanisms as the ones I've mentioned. The third lesson is that, subject to legitimate exceptions, Parliament must always remain open for business. Otherwise, parliamentary transparency, accountability and democracy can neither exist nor appear to exist. Now, we take this for granted in the United Kingdom. I speak here as a British citizen, although I've been living in the Republic of Cyprus since 2015. We take it for granted that our Parliament is there. It's functioning. We also take it for granted that we're not going to be at risk of a coup d'etat or an invasion or an occupation or some other form of upheaval that will result in our Parliament shutting down for any great length of time. And that's a privilege, of course, of living in a relatively trouble-free democracy, but it also means that it's all too easy to become complacent. And arguably, the Prime Minister became complacent when he decided to advise the Queen to prorogue Parliament and keep it closed for a period between 9th to 12th of September 2019 until the 14th of October 2019. Now, on the face of it, that doesn't seem as though it's a particularly long period for Parliament to be shut, just over a month. But that was perhaps one of the most pivotal months in post-1945 British political and legal history. It was the month in which, at the time, we thought that Brexit was going to take place. And the Prime Minister took a decision to prorogue Parliament. Now, he has the right to call for the prorogation of Parliament, but the question arose as to whether the decision to prorogue Parliament for that length of time during such a pivotal period of history was lawful or unlawful. And that question went to eventually ended up in the Supreme Court of the United Kingdom in the case of the Crown on the application of Miller and the Prime Minister. And there was a parallel litigation in Scotland that ended up in in the Supreme Court as well. Now, in addressing, and there was a unanimous judgment from the Supreme Court in what was called the second Miller case. There was a division of opinion in the first Miller case, but in the second Miller case, the Supreme Court reminded itself that in the first Miller case, Lord Carnwath had described parliamentary accountability as a constitutional principle no less fundamental to our constitution than parliamentary sovereignty. And they went on to refer to Lord Bingham's remark that the conduct of government by Prime Minister and Cabinet, collectively responsible and accountable to Parliament, lies at the heart of Westminster democracy. Now, that's the difference between a French or US or Cypriot style presidential system, where there's a much clearer separation of powers between the three branches of government, particularly the executive and the legislative, and the British parliamentary model, where there is almost a fusion of parliamentary and governmental functions. And I'm reminded of the classic book, the English Constitution, politically incorrect phrase these days. We're supposed to refer to the United Kingdom Constitution, but Walter Bagehot in his classic book, the English Constitution in the 19th century, focused on this near almost complete fusion between the legislative and executive branches of government, which is in a sense a violation of the separation of powers, but it's arguably a strength, because it means that Parliament is in a very good position to hold the executive to account. It also means that the executive, if it's got a parliamentary majority, can effectively pull Parliament along as if it's a dog at the end of a string. But the point is, that's the classic feature of parliamentary democracy under the Westminster model, and that is that was put at risk, the Supreme Court held, by this excessive period in which Parliament was closed. And the Supreme Court, the details are in my handout and in the full judgment, and the Supreme Court held that the decision of the Prime Minister to keep Parliament closed for so long was unlawful, and therefore the decision was quashed. That being said, the second Miller case that I've just referred to has a much wider significance. In common with the Chater case I referred to earlier, it reminds us that the rule of law matters, and nobody, not even a Prime Minister who commands the support of a majority of members of Parliament in the House of Commons, is above the law. Nobody is above the law, and the Miller case, the second Miller case, reminded us of that. And in my handout, I've given you details as to what the rule of law entails according to the late Lord Bingham, as endorsed by the Venice Commission of the Council of Europe. In the last 5 or so minutes, if I may, I'll just race through the last 3 lessons, which flow from the first 3. The 4th lesson is this: every parliamentarian must ensure that their private life, and if they have one, their business or professional life, does not have and does not appear to have any adverse consequences upon either the public office that they hold or the public duties that they perform. Now, if any of you have never found out about the Profimo Scandal, I encourage you to read about the Profimo Scandal and to find out as much about it as possible. It's one of the most sensational scandals in British political history, and it illustrates vividly the point that I just made. In 1963, the world discovered that the then Secretary of State for War and ministerial head of the army, John Profimo, had an affair with, he was married, he had an affair with an unmarried woman called Christine Keeler, and it was alleged Christine Keeler had an affair with the then Soviet naval attaché in the Soviet embassy in London, who was accused of being a spy. So here you had a minister of the Crown who's married, having an affair with an unmarried woman who's having an affair with the Soviet naval attaché at the height of the Cold War. This was just after the Cuban Missile Crisis, for example. This created an almighty fuss in Fleet Street in the newspapers when they discovered it, and the John Profimo went to the House of Commons and he denied it. He denied having the affair, and he claimed that there was no impropriety between him and Christine Keeler. Well, that turned out to be untrue, and John Profimo had to resign as both a member of Parliament and as a Minister of the Crown, and he was effectively he disgraced himself as a result of saying something that was untrue to Parliament. Now, I'm mentioning him because here was a classic example of a member of Parliament muddling up his private life and his public life. Now, every member of Parliament is entitled to a private life under the Human Rights Act and the European Convention on Human Rights. But go back to what I said earlier, appearances matter. And that was one of the things that went wrong with John Profimo. What he was doing in his private life appeared to cut across into his public duties, and he paid the penalty as a consequence. But of course he resigned because he lied to Parliament. That's another issue. The ministerial code makes it quite clear that ministers must ensure that no conflict arises or appears to arise between their public duties and their private interests. I have to say here, when I first came to the Republic of Cyprus, I wrote to the presidential palace and I asked for documents similar to this, and I didn't get anywhere. I didn't get a response. And it's very important that we have in the Republic of Cyprus a culture of compliance with principles, such as the one that I've just identified. So that's the fourth lesson. Parliamentarians are entitled to private life, but they must be careful that their private life does not stray into their public duties or the public office that they hold, and that it doesn't appear to. The fifth lesson, and I'm almost towards the end, the fifth lesson is that the truth is the lifeblood of parliamentary transparency, accountability, and democracy. The truth is also the lifeblood of justice. And I've just mentioned to you the Profimo case. I have in front of me the actual words that he spoke in the House of Commons on the 22nd of March 1963, when other members of Parliament on the previous day had insinuated that this scandal had arisen. This is what John Profimo said on the floor of the House of Commons. I thank Hansard for recording this. There was no impropriety whatsoever in my acquaintanceship with Miss Keeler. So that was untrue. He made matters worse, Mr. Profimo, by saying the following: I shall not hesitate to issue writs for libel and slander if scandalous allegations are made or repeated outside the House. Well, he made a rod for his own back, and he paid the penalty. More recent cases include a very tragic case of the Crown and Festus Onasanya and Fiona Onasanya. Fiona Onasanya was both a solicitor by profession and a Labour Member of Parliament when this case reached the Central Criminal Court in London. She, as a solicitor by profession and as a Member of Parliament, should have known better, but she ended up being convicted by a jury of perverting the course of public justice by providing false information to the authorities about the identity of a car that had been driven beyond the speed limit. A relatively petty case. Didn't tell the truth to the authorities when she should have done, and she paid the ultimate penalty. A, she was found guilty. B, C, she ended up facing this new recall procedure whereby constituents of hers were able to call a by-election to have her removed as a Member of Parliament, and she was indeed removed as a Member of Parliament. And then to cap it all, she faced a separate hearing before the Solicitors' Disciplinary Tribunal, which reached the decision that she was guilty of professional misconduct and therefore she was struck off. And this is a salutary case for every single parliamentarian around the world who is both a lawyer or whether practicing or non-practicing, and a Member of Parliament. I'll just read to you what Mr. Justice Stuart Smith said in his sentencing remarks, dated 29th of January 2019. The fact remains that both as a solicitor and as a Member of Parliament, you, i.e. Fiona Onasanya, are fully aware of the importance of upholding the proper administration of justice, You have not simply let yourself down, you have let down those who look to you for inspiration, your party, your profession, and Parliament. The impact of your conviction has been disastrous from you. You've been expelled by the Labour Party, and it seems inevitable that you'd be struck off as a solicitor. I make plain that I will not treat you more severely because of your position as an MP and former solicitor. That said, as counsel accepted on your behalf, there cannot be one law for those in positions of power, privilege, and responsibility, and another for those who are not. You had a choice on the 2nd of November 2017 whether to tell the truth or to attempt to pervert the course of public justice. You made the wrong choice with disastrous consequences. So in different circumstances, the Onosanya case is very similar to the Profimo case in that an untrue statement resulted in somebody's fall from grace. And in a sense, that is parliamentary accountability in action in the broadest sense of the term. I mean, countries such as the Republic of Cyprus may want to consider following in the footsteps of the UK Parliament that has enacted the Recall of MPs Act 2015. That's a story from the day. The final lesson, I'm looking at the clock here because I've run out of time. The final lesson is that every parliamentarian and other person holding public office must abide by the 7 principles of public life. I've noticed that in the Republic of Cyprus, the new code of conduct for MPs is very long. It goes from page after page after page after page. What I would suggest the Republic of Cyprus might want to do is to adopt the 7 or either the 7 principles of public life or a variation of them. These were introduced in the United Kingdom in 1995 in the aftermath of the series of scandals culminating in the so-called Cash for Questions affair. And I'm reading here from Mr. Justice Warby's summary of that case in the case of Yo in Times newspapers, which has nothing to do with the Cash for Questions case, but the judge just went back to trace the history. And he said, as is common knowledge, the establishment of the Nolan Committee, which resulted in the 7 principles of public life, followed the Cash for Questions scandal, in which certain MPs were accused of, this was back in the early 90s, were accused of accepting bribes in exchange for asking parliamentary questions and undertaking other tasks on behalf of Mohammed Al-Fayed. So that was the then, back in the early 90s, Cash for Questions affair, and it gave rise to the 7 principles of public life. And here are the 7 principles of public life. And I won't read to you the explanations that underpin them, but here they are. Number 1, selflessness. Number 2, integrity. Number 3, objectivity. Number 4, accountability. Number 5, openness. Number 6, honesty. And number 7, leadership. So in closing, let me just say this: parliamentarians and other holders of public office around the world would do well to reflect upon the 6 lessons of British politico-legal history identified in this paper. Such holders of public office would also do well to act in line with the 7 principles. In a sense, they are not British principles, they are universal principles with an ancient heritage. After all, each one seeks to promote an intrinsically Aristotelian approach to ethical, virtuous, and otherwise good conduct in the public interest. And they do provide an antidote to what Churchill described as this world of sin and woe. Thank you for your time.
Thank you very much, Klearchos, for spending so much time and energy preparing for this and giving us a very, very informative and a complete paper. So this is, I think, materials which participants can take away with them and that complement very nicely what Saira has been presenting to us. So thank you both for those your insights. Now we have half an hour for questions and answers. And I don't know if there are any answers or questions from the floor. Let me see, from the audience. Yes, there is a question.
Stéphanie,
yes, there is a question in the chat. Is that what you wanted to say, Andrea?
yes, sorry for that.
Okay, no problem. Thank you. So there's a question to Klearchos firstly, but I'm sure that you know, we could widen it a little bit. It's about the state of Singapore, so I'm not sure that any speaker is actually qualified to answer this, but okay, you have the question in the chat. The great state of Singapore under the guidance of Mr. Lee Kuan Yew has been implementing since its inception these two principles of accountability and transparency that Klearchos characterized as the most important for the existence of democracy. Singapore is also and has always been undeniably one of the least corrupted states in the world. Yet it has always been criticized, especially by the Western press, as undemocratic. By what you had suggested, those views are completely unfounded. Do you agree? This is from a guest on the webinar. Klearchos, would you like to say anything about this?
Well, first of all, I'm grateful to whoever it was that asked me that question. I have to follow one of those 8 principles, honesty. And no, I'm not a holder of public office. I don't know the answer, so I don't feel qualified to either comment on what has been said or even to answer the question in the first place. So I'm going to duck out. But what I would do is ask the reader to go away and research the subject, and maybe email me, and I can give it some further thought in the fullness of time. But I don't know enough about the history of Singapore, other than that it played a major role in the Second World War, and it has a long relationship with the United Kingdom, and it's often portrayed as a semi-role model with a sort of a patchy history that cuts both ways. I'm not going to go beyond that, but Singapore is a fascinating country, and I'm grateful to the questioner, but I think I'll limit my remarks to what I've just said. Thank you,
Klearchos. I think while we are expecting more questions in the chat or hands up, I would have one question that is related to Saira, not related in terms of Singapore, related in terms of what does the UK Parliament do in terms of international reporting or reporting against international benchmarks in the field of transparency and accountability? So we spoke about progress reports from the European Union, progress reports from the Council of Europe. Is there something in particular that the UK Parliament either participates to or actually does itself in this field?
There is not, to my knowledge, anything that the UK Parliament does itself independently. I believe that we participate in some UK reporting, but I'm afraid that I don't know the details. I'll get back to you on that if I may.
Okay, thank you.
Could I please ask Saira a question? It's to do with the structures of legal advice within the UK Parliament, or perhaps the House of Commons in particular. Could Saira please outline how legal advice is tendered in the House of Commons, and what are the contrasting roles performed by the Attorney General, Speaker's Counsel, Parliamentary Counsel, and any other lawyers who are involved? And side by side with that, what is the role of the clerk to the House of Commons?
Mm-hmm.
That's quite a collection of questions. Thank you. Starting with the provision of legal advice, the Attorney General, put very simply and briefly, is the government's legal advisor. Historically, the Attorney also had a role in advising Parliament, but that has in practice fallen away in recent years. And as we've seen during the Brexit process, there have been times when the Attorney's advice has itself been a matter for parliamentary scrutiny and examination, and indeed requests by way of humble address to get copies of the advice. So that's the attorney's role. Parliamentary Counsel are the legislative drafters for the government, notwithstanding their title. Very confusingly, people who do my role in other jurisdictions are quite often called Parliamentary Counsel, and the people who do the drafting are often called Legislative Counsel. But in the UK, I'm Speaker's Counsel and the drafters are Parliamentary Counsel. They are civil servants. They work for the executive branch of government, not for Parliament. And that brings me to my role. I advise the Speaker, the Clerk and committees of the House, and also the House Service, the backroom functions of the House of Commons. And I have a team of 20 lawyers, and including a number of advisors to specific committees. So, for example, the Joint Committee on Statutory Instruments has its own dedicated team of legal advisors who analyse secondary legislation for the committee. There are also human rights specialists, European law specialists who also work on other forms of international law, and the general advice team who do all the things that you would expect in-house lawyers to do in a big organisation. So contracts, employment, procurement, freedom of information, data protection requests, and essentially anything else that arises, including liaising with the police in criminal cases. And then your second question was about the role of the clerk, which is a really interesting role, actually, and it dates back to, don't quote me on this, but I think 1265. The Clerk of the House of Commons is a very long-standing office indeed. It makes my role, which has only been around since 1840, look positively nouveau. So the clerk is responsible for procedural advice to the House. That's the long-standing, very old part of the role. It's also because he's also the head of the House Service. That means that his role has accrued other functions over time. So he is responsible for setting the tone for members of staff. He's responsible ultimately for all decisions about how the House Service is structured, how its departments are set up, and so on. And he also holds the statutory office of Corporate Officer, which, as I said, is a corporation sole and is inhabited by the clerk from time to time. And that means that he is the corporation that has legal personality and can contract on behalf of the House, and also hold land. All the land other than the Palace of Westminster, which is obviously a royal palace, is held by one or both corporate officers on behalf of the two houses.
Thank you for that answer. There's a reason I asked my pair of questions. It's to sort of implicitly make the point that in a democracy, everybody must obey the law, including the legislative branch of government that makes the laws. And therefore, it's important for any legislature around the world for there to be internal structures of legal advice for the parliamentarians and the authorities within Parliament to obey the law. And it's an often overlooked feature, this, that we tend to focus, partly because of judicial review and constitutional review that they have in the Republic of Cyprus, we tend to focus on the importance of the legislative branch, the executive branch of government, headed by a president in a republican regime such as ours in the Republic, or the Prime Minister in a Westminster style democracy. We tend to focus on the importance of the executive branch complying with the law. And yet what our UK parliamentary structures show is that, and our history shows, is that Parliament must obey the law. And that's why it's very important for there to be these office holders who act as guardians of the rule of law in the legislative context. So that was the mindset underlying my question. So thank you for the answer.
You're most welcome. It's a good point, and that explains, I think, in large part why those statutes were felt to be necessary, because in the absence of the statutory bodies, the Commission and the Corporate Officer, it isn't clear where legal responsibility sits within the House.
Yes.
But who's responsible for something? It's much more difficult to enforce it.
Incidentally, our students in the audience may realize that there is, a whole world of opportunities working for the legal services or the internal legal structure of the legislative, which is not something that you probably think about when you graduate from law school. But it's certainly an area where there are many opportunities, not only in the legal process, but also in terms of research. And I wanted to come back to the very good resources that both of you have shared with us, and just highlight the importance of the research done at the UK Parliament. So, you know, within the framework of the public consultations that you both, Klearchos mentioned, and Saira also spoke about the right to petition. There is a lot of research ongoing at the UK Parliament, or indeed any other parliament. I can think of the French Parliament. And for the UK Parliament, I mean, I would encourage everyone listening now to actually connect to the POST resources of the UK Parliament, whereby not only public consultations are being scrutinized, and but also other tools are being used, such as database of experts with surveys, questionnaires, focus groups, research scoping papers and reports, and so on. So, and in times of COVID, for example, it's been a real source of you know, of accurate data, but not only, also in times of climate challenges. So every time there's a societal challenge, then there is usually a call out for experts and researchers to contribute to those contributions, to those publications of the UK Parliament. So I just wanted to bring this to the fore, because again, this is an opportunity for professional development, not only for academics, but also for young law graduates who are wondering what to do. Now, we don't have any other questions in the chat, but I would have one for the two of you, which is related, linked to what Klearchos was asking before, actually. I wanted to perhaps emphasize a bit more the intersection of the exercise of parliamentary privilege and of professional duties, because we have actually come across it quite a few times tonight. Of course, what comes to our mind is lawyers who are MPs, but of course there are other regulated professions among members of parliament, whether in Cyprus, whether in the UK, whether in France, whether in any other countries. What else could we say about this intersection of, you know, the exercise of parliamentary privilege, which Saira has very well explained, and the professional duties, which you have explained as well, and Klearchos has actually illustrated with striking examples. So is there anything else we could say to perhaps also inform our audience?
I have an observation about, if you don't mind my going first, Klearchos, about the way in which professional obligations can sometimes conflict with parliamentary privilege, which is when people are appearing as witnesses before committees, and this occurs most problematically for lawyers, but I think it would be true of other professionals with duties to their clients as well. And that is where a lawyer who is giving evidence to a committee is asked a question about something which is subject to legal professional privilege, and which is the subject of client confidentiality, and which their client has not authorised them to speak about. And in that situation, the lawyer is placed in the very difficult position of having either to be potentially in contempt of Parliament by refusing to answer the committee's question, or in breach of their duties to their client if they do answer it, which could lead to potential proceedings for professional misconduct. Although at that point I would step in with the professional body and point out that the evidence of the breach was covered by Article 9 of the Bill of Rights and therefore could not be used in the proceedings against the lawyer in question, or indeed the other regulated professional. But it's a very difficult and uncomfortable position for somebody to be placed in, and it's one that on the whole committees try to avoid by asking the question of the client rather than of the lawyer.
Thank you, Saira. That's very, very helpful. I dare to ask how often is this happening, that you actually have a lawyer in that position? Is it something that happens quite regularly?
No, it's rare. For one thing, a committee would usually invite the client, the key player, the person who had actually made the decision that they wanted to interrogate, rather than their legal advisors, to attend the committee and give evidence. And for another, committees are generally quite mindful of people's professional obligations and will try not to put them in a position where they might be in breach of them. It's happened, to my knowledge, 2 or 3 times in the last 12 years.
Thank you very much. Klearchos, do you want to add anything?
Yes, I will refer to a problematical feature of parliamentary privilege that's come to the fore on a number of occasions recently. I won't mention any names, but the general principle is that a member of parliament or a peer can stand up and say something on the floor of either house without fear of facing defamation proceedings or other proceedings. And what has happened in recent years, partly as a result of the Human Rights Act and its adoption of the right to private and family life, is that a number of individuals have gone to court and obtained court orders for one reason or another. And some of those court orders are to do with Article 8, others are to do with settlements arising from disputes of one sort or another. We've had a number of cases in recent years whereby, I won't mention which house even, a member of one of the 2 houses of parliament has gone onto the floor and blurted out the details of a court order ordering the media to not report on a particular case. Now, the general principle is open justice. So we should, as a general principle, have access to court orders and court judgments. But there are exceptions to that if it's in the public interest and if the court determines that that is the case. Now, in a democracy under the rule of law, we must have a separation of powers. And for the separation of powers to function effectively, each of the 3 branches of government must respect the rights and privileges of the other 2 branches of government. So the system of absolute parliamentary privilege that attaches to members of both houses of the UK Parliament is welcome and necessary, and it's part of our separation of powers because it shields members of Parliament from civil, perhaps even criminal proceedings. I'm thinking there of the Duncan Sands case from the 1930s. I will mention this because he's dead now. As Duncan Sands was allegedly in breach of the Official Secrets Act by disclosing on the floor of the House of Commons certain details about the inadequacies of the radar, if I remember correctly, the radar system that we had in the lead up to the Second World War. And he couldn't be charged with an offence because he was protected by absolute parliamentary privilege. So there is and that helped in a sense to wake people up to the deficiencies in our defences in the lead up to the Second World War. So in a sense, there's a logic behind parliamentary privilege. But the point is, if a court order has been issued and the court order has prohibited certain details from entering the public domain, it's surely incumbent on A, ministers of the Crown in the executive branch of government, and B, ordinary members of Parliament in the legislative branch of government to respect that court order. The case that I have in mind, which I'm not going to mention, I actually read the judgment that was at the heart of the case. It was anonymised. The parties to the case were anonymised, and the judges had gone through the pros and cons of releasing the names into the public domain, and after a very carefully worded judgment in which they weighed up the arguments for and against disclosure, the judges held that it was in the public interest for there to be non-disclosure of the names in question. A certain member of one of the 2 houses of Parliament took it upon himself, having got wind of this judgment and the details, to go onto the floor and to blurt out the details. And what happened next was that the newspapers and the television stations, using a qualified parliamentary privilege, echoed the allegations and the names, and the person who was supposed to be protected by the court order ended up not being protected by the court order. Now, that particular case that I have in mind is a classic example of a member of Parliament or a member of the House of Lords violating the separation of powers and causing damage to the rule of law as a consequence. I'm reminded of what the great US Supreme Court Justice Potter Stewart said: ethics involves doing what is right rather than exercising your right to do something, or words to that effect. The point that Supreme Court Justice was making is just because you have a right to do something doesn't mean that you should do it. And that member of the House of Commons or the House of Lords had a right to go to the House of, well, this is arguable actually, but it's arguable that he did have a right to go onto the floor of the House of Commons and violate the court order in exercise of his right under the Bill of Rights and the privilege that accorded to him. But I would suggest that was unethical, highly unethical, and damaging to our system of justice, which relies upon compliance with court orders by everybody. So parliamentary privilege, to sum up, is a necessary feature of parliamentary democracy. It protects members of parliament. It enables members of parliament, as in the Duncan Sands case, to raise matters which need to be raised and without fear of facing either criminal or civil proceedings. But on the other hand, that right to speak in Parliament must be exercised with discretion and care and without undermining the rule of law. So that's my answer to your, my response to your question with reference to one or two specific case studies.
If I could come back very briefly on that point, because there were some really interesting issues in there. Another parliamentarian, rather less distinguished than Winston Churchill, once said that privilege is not a privilege if it can't be abused. And I think that what you're describing is essentially an example of an occasion when privilege can be abused. It's very hard to devise any system that would ensure proper freedom of speech in both houses of Parliament for all the wide range of purposes for which it might be needed, which might, as you say, include breach of statutory provisions in certain circumstances to highlight inadequacies or whatever it might be, and yet won't allow breach of a court order, because it's perfectly possible, without commenting on any individual existing cases, to envisage a scenario where actually a court order is not fair and is not reasonable and has not been properly made, and that somebody is being very oppressively treated by it. And at that point, the only recourse anybody has got is to interest a member of Parliament in the matter and try to persuade them to wear it on the floor of the House. And it's going to be very rare that that sort of case arises, but any system that we devise has to allow for that possibility.
Yes, the only response, thank you for those comments. The only response I would make is that in the case I had in mind, the appeal process had not even been exhausted. So in a democracy under the rule of law, the parliamentary privilege in that particular case should not have been exercised unless and until the case had gone up to the Supreme Court and all avenues had been exhausted, and the member of Parliament or peer in question, exercising their conscience, did what they did. But that was one of the things that was outrageous about that particular case, that the appeal mechanisms had not been exhausted, and therefore
I don't think we're discussing that privilege can be abused and used in an unethical way. It's what I'm trying to highlight is just the difficulty of devising a system of rules for its exercise that won't end up prohibiting some perfectly proper uses.
Yes, and what's proper or improper, of course, is the big question. And I mean, just for the benefit of the students, I just want to emphasise that in the British parliamentary tradition, certain, as was stated in that case I cited earlier, I think it was the Chater case, certain matters are dealt with by the House of Commons or the House of Lords authorities using their internal mechanisms, which mean that certain types of cases do not go to court. They can be dealt with in-house, and alleged abuses can be dealt with through the parliamentary process. Other types of cases, such as the Onosanya case I mentioned, are properly for the courts. And the Chater case was properly for the criminal courts as well. So it's important for the students to understand that there is this balance between, on the one hand, the internal mechanisms of Parliament, and on the other hand, the judicial mechanisms of the judicial branch of Parliament. Each have its own very important role.
Yeah, thank you.
Sorry.
Saira, please.
I was just going to add to that perhaps it's worth also stating that the important thing is that Chater's behaviour, which constituted the offence, was not found to be a proceeding in Parliament. If what he had done had been a proceeding in Parliament and therefore had been squarely within Article 9, however much the court had disapproved of it, it would have been unable to take any steps against him in respect of it.
Mm.
And the other interesting thing about the Chater case, it was for the courts to decide whether it was within or without the proceedings of Parliament as set down in the Bill of Rights. So then again we have the court as a backup mechanism to interpret the relevant law that is applicable to the House of Commons. That doesn't always apply, of course, but one of the functions of the court is to interpret legislation. And in that particular case, we did have the legislation in the form of the Bill of Rights. But in other cases, correct me if I'm wrong, sorry, that the courts would just not interfere because they would say, well, this is purely a matter for the internal procedures of Parliament, and it's not for the court to stray into this particular area because it's within the jurisdiction of the parliamentary authorities.
Exactly, and the quintessential case of that, of course, is misleading the House, which will always be a matter for Parliament itself and not for any outside authority.
Yes, and in the case I mentioned, John Profimo, he was censured through a motion that was put before the House of Commons in, I think, the summer of 1963. He wasn't brought before any court of law for misleading Parliament. He was dealt with under the internal procedures of Parliament. Although I think he was also stripped of his Privy Council status, which was a matter for the executive branch of government. I mean, these are the peculiarities of the British system of governance. And they've worked by and large over the years. And one of the things we need to ensure is that they continue to operate, because we're living in an era where certain politicians around the world, and we're seeing them in our part of the world, they think they're above the law and that they can act in a cavalier manner, and that's very, very dangerous. But it's spreading into elements of the West as well, which is very troubling for those of us who can draw comparisons between the Eastern Mediterranean, where abnormal behaviour has almost been normalised, and Western liberal democracies that really ought to be above that type of behaviour.
So let me thank you both. Let me perhaps, draw some conclusions, very, very brief concluding remarks, and perhaps two aspects that I take away and that probably require more work and more research and more exchange. One aspect is what we just mentioned. Actually, we mentioned both right now. One is the extent of the freedom of speech at the House, at the expense of perhaps other rights and other principles. So I think this, to me, is clearly an area where there is a lot of room for discussion. And the other one is the extent to the right of information, and in the context, in particular, of national security. Saira mentioned it, and she did say that in the past decades there has been quite a lot of use of national security and the prevention and detection of crime in the balancing exercise to decide whether information can be disclosed or not. So this is very interesting and very important, because from the Cold War scenario that Klearchos painted for us to today's scenario, there is of course a big difference in the way national security is considered, especially in the context of data protection. But also there is an increased role in all countries, including Western societies, for the detection of crime and the detection and the prevention of crime. So I think this is also an area where there should be more discussion And I thank you both very, very much for your time. Saira, it was a pleasure listening to you. Klearchos, of course, to you as well. I would like to thank all the attendees who have actually stayed with us until the end. Thank you very much for sticking to us. We are finishing right on time. Attendees, participants, could you please fill in the feedback form? You've got it in the chat. Thank you very much. And our colleagues from the British High Commission and from UCLan Cyprus for supporting us. It's been a pleasure. We will stop the recording and we will greet you. Farewell. Bye from me now.